Hello and welcome to ThePrint. This is Bismee Taskin, Principal Correspondent at ThePrint, covering crime and national security here in New Delhi. With me today we have Mr. Bhuwan Ribhu, child rights activist, lawyer. He is also the founding member of Just Rights for Children Alliance, a petitioner in the Supreme Court case where the top court had come down with a landmark verdict against sharing of child pornographic content. Now, the Supreme Court in this landmark verdict has clarified that viewing, possessing and not reporting child sexually abusive content is an offence under sections of the POCSO Act and the IT Act. The top court also set aside a Madras High Court judgment that had come earlier in January this year, squashing legal proceedings against a 28-year-old man. Welcome to ThePrint, sir.
Thank you very much for having me.
My first question to you is if you could explain it to our viewers on why this verdict is important, why it is a landmark judgment that the Supreme Court passed last month.
This judgment is a groundbreaking judgment on a variety of aspects. The first being that the Supreme Court agreed to hear this case at all. In normal criminal jurisprudence, what happens is that either in case of a crime, the state goes in appeal or a victim goes in appeal. Now, here was the case where the victim was nameless and not known. This man had searched for child pornographic content, had searched for rape of children, had downloaded this rape taking place and had continued to watch that. For over 2 years, he also was in possession of this. This man had been identified by international agencies, the data had been shared by them with India, and the central government National Crime Records Bureau had passed it on to the Madras police. The Madras police had actually taken prompt action, arrested this man and initiated these criminal proceedings. Subsequently, the Madras High Court quashed the FIR and let the man go scot-free. Either the state could come in appeal. This is why the Supreme Court ruling is so important. Either the state could come in appeal or the child could come in appeal. In this particular case, the state had not gone in appeal and it was an indignation, it was an affront to civilized society that a person who is creating the demand for child rape by searching for such videos, by circulating or keeping these videos and showing them around, was simply not found guilty of any offence or any crime. So, we came together as a group of 120 civil society organizations led by 5 organizations that created the Just Rights for Children Alliance movement and trust, and approached the Supreme Court to take action under a special leave petition. Thankfully, the Supreme Court created a new boundary for criminal jurisprudence and for justice delivery by allowing the civil society organizations to also approach the Supreme Court in a matter of criminal law. This was the first instance. The second most important part is that in India, where the general perception is that the cases will take on years and years and years, and once you have approached the court, the justice is miles away. In this particular case, the Supreme Court of India admitted the petition in February, heard the arguments in March and beginning of April, and reserved the judgment in April. Within 6 months, the Supreme Court gave the first of its kind landmark judgment that on one side did away with the idea of intention of crime. The Supreme Court has said if you are downloading child sexual, exploitative and abusive material, if you are downloading child sexually exploitative and abusive material, you are guilty. You are supposed to report it immediately to the concerned authorities if it has come to you by mistake. You are supposed to report it to the government if somebody has forwarded it to you and if you have not solicited it. That is one. Secondly, the Supreme Court expanded on the definition of child pornography itself. The Supreme Court said that pornographic content which was only limited to video or pictorial depiction of digital nature is different than child sexually exploitative and abusive material, which can be anything which is detrimental and harms the child. This expansion of definition and laying down a new terminology is a global precedent in its own right. And this is something that the entire world, I believe, at some point or the other is going to move towards. The third thing that the Supreme Court did was that, of course, it not only quashed the Madras High Court judgment and said that mere downloading is a crime, but also made provisions for prevention. It said that sex education should be mandatorily taught. It also said that the intermediaries like the social media companies are going to be held accountable now. They are supposed to report whenever such a thing is coming across Telegram, Instagram, WhatsApp, Facebook, and any other social media company which is doing business in India. If a crime is happening through your social media company, you are duty bound to report it to the Indian authorities. This by itself is going to be a game changer. So, these are some of the salient features and salient points of the Supreme Court judgment, and that I think is therefore a landmark ruling.
Right. Just to let our viewers know, sir, if you could also explain to our viewers a little bit more on how the intention of crime in these particular cases comes to play and what the Madras High Court had said while squashing the legal proceedings in this case.
So, as I explained earlier, here was this man who searched for child at that time pornographic content, now CCM. Child sexually exploitative and abusive material would be termed as CCM. This man searched for these videos, downloaded these videos, did not report these videos and continued to keep them on his phone. He was not identified through a process where someone had reported within India after watching these videos. He had been identified because he was searching for these videos online, and some international law enforcement agencies had tagged his IP address and had forwarded the same to the Indian authorities. This is it's a procedure which has been established by the Ministry of Home Affairs, by international agencies such as Interpol, and which is being followed across India, because this content, all these intermediaries were giving this content to an agency in United States. From United States it was coming into India, and by MHA it was being forwarded. This entire process was actually done away with, because the Madras High Court actually did not look at the fact that this man was actively searching, and looked at the case in a mechanized way, wherein the Madras High Court said that because this man had downloaded this material, it could have been by accident, and if he did not delete it, that does not mean that he has committed a crime under section 15(2), which is a specific offence. The Supreme Court said law should not be read in isolation with certain offences only. Section 15(1) talks about one part of the crime, section 15(2) talks about another part of the crime, section 15(3) talks about another part of the crime. One is collection, the second is downloading, and the third is circulation. This man may not have been guilty of circulation, but he was or even might have mistakenly downloaded, but he was certainly guilty of collection and keeping it in storage. And once the law is clear that he is duty bound to report, ignorance of law cannot be an excuse. And this man taking a plea that the law did not exist when he had first downloaded does not really hold true. Home to a very large number of people who are actively searching for child sexually exploitative and abusive material. Research done by one of our partner organizations, the India Child Protection Research Team, about 4 years ago had suggested that there was a 200% increase in the demand for such child pornographic content in the first 1 week of COVID. So, the last reports which had been shared with India in 2022 also suggested that over 5 million files and 5 million IP addresses of people, 50 lakh IP addresses of people had been shared by the international agencies with the Ministry of Home Affairs of possible exploiters of children or possible people who are downloading this. Because the Supreme Court has held that there should be an expert committee that mandates that these reporting frameworks should definitely be taught in schools. That is going to be also very important. I will give a very small example. In India, the procedure of reporting this is that if I was to receive such a content, then I should immediately report it to the social media company. There is a report button. People do not know about it. After I press the report button on the WhatsApp message or the whatever social media message, report as an abusive content, report as an offensive content. After I press this, I can also report it to the central government. I can also report it to the portals which had been created by the statutory authorities like the National Commission for Protection of Child Rights and other bodies. India has a phenomenal law and guideline on this issue. That guideline states that if the government was to ask, the designated authority of the government was to ask these social media companies to take down this offensive content, they have to take it down, no questions and no debate on the issue. Which basically means that if a child or a woman is being exploited and if she or the child was to report this matter to the authorities can immediately take action to direct the intermediaries to do away with such content. And because we are increasingly seeing cases of sextortion, cases of grooming, cases where sometimes the images or the videos are self-generated, cases where relationships have gone sour and people are now blackmailing the other party, cases where young children are being sent these messages and harassed, they are being stalked, they are being abused. So, all of those things are going to change because the intermediaries will also be now duty bound to report these cases to the local police, and the law is clear that the police is also duty bound to act.
It's been a while that the FBI and the Interpol has been working with the Central Bureau of Investigation in India, to curb down this child sexual abusive content. However, in spite of these landmark judgments, and this I'm asking, sir, because there have been landmark judgments in cases of rape and other sorts of crime against violence against women and children as well. What do you have to say about the future implementation of this particular verdict? Do you think the Indian police is equipped and will be able to, and is aware enough to, to not just crack down, but also to build a watertight case so that the people possessing, viewing and, circulating child pornographic content are brought to justice?
Is the law or a judgment enough? The direct answer is probably not. In this case, however, there is a difference. If this judgment had not been there, then the law that applies in the country would have been that downloading of child pornographic material, downloading of child rape videos was not a crime. If people were to search for these videos, ask for these videos, that creates a demand for child rape. This demand leads to more crime. Regardless of the geographical boundaries, whether that child is being raped in India or is being raped elsewhere, it would have been the same. The law will mandate what is right and what is a crime versus what is not. The law would mandate what is right and what is not. The law would mandate what is a crime and what is acceptable behavior. In this particular case, the Madras High Court had said that searching for child rape is not a crime which would allow people to do that. That had to go away. So, just the fact that the Supreme Court said this is unacceptable, this judgment is being set aside, immediately the law is clear. So, the law will define that morality and that conduct. So, that by itself is sufficient. However, the court has not stopped there. It could have been a one-line judgment. The court has gone much beyond. And what the court has done is that it has created the framework for action. It has given the weapons, the teeth. It has given the police what they need, and it has also given the public the direction in which they have to go to be able to support these children and do away with this crime. The children cannot wait, and one child raped in the absence of law, one man who is advocating for or supporting or abetting or even creating the demand for child rape, walking away is one person too many. And therefore, the Supreme Court's moving forward from conventional setting aside of the judgment into the domain of building capacity, building the institutional framework, building the preventive models, building the committees that are going to create the modules for this education, and also creating the terminology which would assist children not only in India but globally. That is the key. So, this judgment is different than all the other judgments. In fact, one can say that there have been very good judgments, but then there are some that are pivotal in the fight for the protection of rights. One can talk about the judgment of Keshwa Nandan Bharti. One can talk about the judgment of Bachpan Bachao Andolan versus Union of India that led to over 100,000 children being saved each year from being trafficked or from going missing. One can talk about the Vishakha case that led to prevention of sexual harassment guidelines across India and in many other countries. This is a pivotal case. Child rape and sexual abuse is changing its form. It is no longer the rape or abuse which is being done by one criminal on one child alone. This C-seam creates a system of organized crime where this child's exploitation is continued through the circulation of the videos. Imagine the plight of a girl whose video is perpetually available online. Imagine the plight of a child whose parents have to not only bear the trauma but also witness it all the time because they know that it is available and people are watching and seeing. That perpetual rape, that perpetual abuse, that perpetual exploitation needs to stop. And that is where this judgment is going to be pivotal.
Earlier, the Print had launched an investigation into social media apps like Instagram and Telegram, promoting and propagating child pornography content. And what we saw is that this sort of material was available on Telegram for amounts as low as rupees 25 to 50. Now on Instagram, when we looked at it, there weren't videos of child pornography content. Instead, there were links that were directing users from Instagram to Telegram. For our viewers, we will be providing a link of this story as well in the video's description. So my question to you is, since you mentioned about intermediaries and how social media companies will be liable, how does a user report on such content? Reporting on social media apps is one process, but that is a whole lengthy process because to bring down one particular content, 15, 20 or some approximate number of people need to click on the button. How a user who has viewed such a content, who is a part of such Telegram groups, can report it to the police? Under what sections can this particular complaint be filed, and how does this stop? Because in Telegram, like I mentioned, we have seen that it's an amoebic problem. They have their own channel which they provide statistics saying that we ban lakhs of such channels on regular basis. However, these channels keep mushrooming every now and then, and this appears like a never-ending problem.
The CEO of Telegram was arrested recently on these charges in Europe, and the Supreme Court ruling is that weapon that allows a person to actually report this to the intermediary, and the intermediary is duty bound to report it to the police. However, as I said earlier, any person can report this content to the local police, to the government portals which have been created. There is an India Cyber Crime Coordination Center under the Ministry of Home Affairs, which is called I4C, and you can report it to the I4C. Also, from your earlier question, any weapon or any instrument for that matter requires to be used. It can be used in a good way, it can be used in a bad way. This judgment allows us to actually use the resources that are available in law. Under section 15 of the POCSO Act, under section 67 of the IT Act, all these things are crime. Downloading, searching for, collecting, viewing, circulating, selling, everything is a crime. Any user who wants to report this content can report it first to the intermediary, can report it to the Ministry of Home Affairs, can report it to the National Commission for Protection of Child Rights, and can report it to the local police. The local police are going to direct. Also, I would like to say anything that the viewer believes is pornographic or exploitative content, anything that depicts a child in a exploitative or abusive manner, anything which is text, audio, video, photograph, even the artificially generated images that seem to depict a child and may or may not be real, even the cartoons, all of those fall within the definition of the child sexually exploitative and abusive material and should be reported. That the police can actually now know who are the sex offenders that might be targeting the children. Eventually, the national database of sex offenders that we have in India, the sex offenders registry that we have in India, should get information about these people as well who are committing these sexual crimes against children, not in the real world but in the virtual world. At some point in time, the person should not be allowed to claim the right of privacy over the right of protection of the society and over others. People who are raping the children, people who are abusing our children, people who are predators of our children need to be known for the protection of our children and for the protection of the larger society. That is probably the biggest door that this judgment opens for the police, wherein when people are tracked, they can be identified, and eventually the entire organized crime syndicate can be traced and tracked through following of the money trail. These offences are either individual offences where there is only one person, but when this video is being sold for 50 rupees, for 25 rupees, this is a part of a larger organized crime syndicate where the exploitation of these children has been made into a business. This is trafficking. This is trafficking. This is organized crime, and this is an economic crime. So, if one follows the money trail, one can also reach and hit the economics of it. Not only the people need to be targeted, identified and arrested, but also the properties which have been generated from the abuse of these children and from selling this exploitative content, that needs to be taken down.
Alright sir, thank you so much for joining us today at ThePrint. Do log on to ThePrint for more such videos. Also follow us on our social media handles.
Thank you for having me. Thank you very much.